evening for all of you. I think this is my first class in Savisa's ambitious program to make future judges, public prosecutors, and other persons in various avenues of life. You know that Evidence Act is a very relevant and interesting act for so many reasons. First of all, whatever law you study, you have to prove the said laws before court. So everything requires evidence. You may be a knowledgeable person, you may be an academician, you may have sound legal knowledge to convince certain facts. But when the legal knowledge need to be proved in a given set of facts, the task is different. Put it other words, law, in my view itself, is a combination of skeleton and flesh, just like human body. A body can't survive either with your skeleton or with your flesh. So every law is fact-oriented. So what is the real fact? That real fact requires to be proved before court. Viewed in that particular angle, Evidence Act is a very important act. First of all, I would like to invite you regarding the origin and development of evidence. I'm not taking much time regarding the historical aspects because historical aspect is nowadays having very little significance. In olden days, the most difficult, the most complex question even today is when an allegation is made against a person, whether that allegation is correct or not. How can you prove it conclusively? Even when the judges at that time decide the correctness of an allegation, there is no systematic, scientific, clear principle to follow. So there are so many examples even from the olden days of history. I think Safisar is very well a devotee of Artigal Bhagavati. And even the story of Kannagi, her husband was charged in a false case. Despite her pathetic plea to prove that aspect, king did not believe, ultimately resulted his execution. Now, this is a history. And being aggrieved by the said decisions, she came back, destroyed the whole city of Mathura. This was an old story, but why I am telling that story? Just to invite you regarding the importance of evidence. Now, in the ancient periods, as we know that there are so many customs, traditions, and principles without any scientific basis depends evidence. Every princely state decide the question of evidence purely based on the then existing social customs and religious principles. So when we are discussing about the origin of evidence for a long period of time, India was under various Hindu rulers, and there is no systematic and precise definition of evidence. In the second stage, we can see that Muslims invade India and they have their own system of rules and evidence. Both under Hindu law and under Muslim law, the system of evidence followed by them is not specific, clear, and most importantly, identical. So, how evidence is appreciated in a particular kingdom is entirely different in a way it is appreciated in another kingdom. This is one of the reasons why, in spite of being the fact that we are ruled by British government who colonially exploit us, we are very much indebted to Indian Evidence Act. Because Indian Evidence Act, in my opinion, is a classic legal document that conclusively, authoritatively establish a uniform system of evidence. This is the most important the contribution of law of evidence. First time in the history of India, a uniform, standard, systematic method of evidence is introduced. We know that the Indian Evidence Act came into force in 1872. Actually, we are in the 115th year, even 150 years after the enactment of this classical and precise legislation. We have made little changes. And those changes are necessitated either because of the technological revolution or because of the two major criminal law amendment acts, the one in 2018 and another one in 2019. Except those amendments, the original text of Indian Evidence Act, which was enacted in 1872, actually it was enacted on 1/9/1872 with 167 sections, with the Act 1 of 1872 by Queen of Great Britain is still followed in India, Pakistan, and Bangladesh. Pakistan recently enacted an Evidence Act with certain major amendments. In spite of that, India and Bangladesh fundamentally retain this Evidence Act. Indian Evidence Act, opening words of Indian Evidence Act itself made it clear that the Act is not applicable to armed forces, Navy, and court-martial proceedings is exclusively excluded from Indian Evidence Act. And Air Force is also excluded. So when we are discussing the Evidence Act, the extent of Evidence Act is concerned, the most important point we must make up in our mind is Army. Army includes Air Force, Naval, and Army is excluded from the purview of Indian Evidence Act. You may be asked why Indian Evidence Act is not applicable to armed forces. This is probably because of the reason that it was a colonial legislation. Even today, Army is having their own separate method of discipline and separate method of adducing evidence. Except to that category, this act applies to all other category except arbitrators. So 4 groups excluded. One is the 3 wings of Indian Army, then the arbitrators. Why arbitration proceedings is excluded from Evidence Act? It's quite, we can very simply say that arbitration is a proceedings where we must be informal. So many admissions, confession is necessary during the process of arbitration. So if we are constrained to take all those stated in arbitration proceedings as evidence, this may be used against us. So even when we are discussing the process of arbitration, the experts of arbitration say that whatever we states in an arbitration proceedings, that comes to an end at the moment the settlement is arrived. The entire thing noted by the arbitrator shall be burned into ashes. There shall be no evidence at all. Even otherwise, whatever proceedings we are discussing in the arbitration proceedings never form part of evidence, because it is a process of persuading a party to reach into a point. At that time, we may even admit the commission of a crime, which is not the subject matter for the arbitrator. So what I'm telling you is that the extent of the first portion, the extent of the Evidence Act is specifically applicable to the whole of India except Jammu and Kashmir. It is applicable to both civil and criminal courts except court-martial and arbitrator. Viewed in this particular angle, we can say that we have only one Evidence Act for both for criminal cases and for civil matters. Another interesting aspect is that in spite of being the fact that this Evidence Act is applicable throughout India and in all court proceedings, we cannot say that in certain major policy matters, certain important decisions, this Evidence Act is not scrupulously or strictly followed. For example, when a bail application is considered by the court, we cannot say that the Evidence Act, whether a particular matter is proved beyond doubt or not. The question regarding may presume, shall presume, conclusive of all those things we will discuss if time permits, is not very seriously considered at the time of granting or not granting a bail. When an injunction application comes before a civil court at the first instance, the court is just considered with the question whether there is a prima facie case, balance of convenience, or irreparable loss. Sometimes the court even grant an ex parte injunction order against another party, not strictly following the law of evidence. Even when an injunction application is heard with after giving an opportunity to the other side also, we cannot say that the Evidence Act is strictly applied in court proceedings. So another interesting aspect is that when writ petitions comes before the Supreme Court and High Court, then also we cannot say that Evidence Act is scrupulously or strictly followed at the time of taking decisions. In spite of all these slight, or you may be considered as a considerable drawback or necessary evil, because in such a situation, we cannot take Evidence Act in toto, because the purpose of Evidence Act is to consider a mixture of oral and documentary evidence before concluding into a final decision. Okay. Then we can rightly ask a question, when considering so many important matters by various tribunals, for example, an administrative tribunal, whether an industrial tribunal in the strict sense, is always adducing evidence before taking the decision, I am afraid to say that no. There are so many tribunals where very rarely oral evidence is taken, cross-examination is taking place. Almost everything depends on the arguments of the counsels and the veracity of the documents. This is an aspect we have to explore. Why? In spite of being the fact that Evidence Act is applicable to all courts except military discipline and arbitrator, it is not seriously widely discussed. Okay. Now, we know that court is specifically defined. Court includes all judges and magistrates. So the word used in the definition itself is court includes. So in order to remove an ambiguity, it specifically used the word judges. Judges include Supreme Court judges, High Court judges, Sessions Court judges, and all types of judicial officers authorized to take evidence. This is the interesting word. Authorized to take evidence. So authorized to take evidence means there are so many categories who are authorized, but because of the positive time, because of the shortage of time, they are not in a position to take evidence in each and every proceedings. This is one of the reasons why we cannot say that judges sitting under Article 226 and 227 under 32 of the Constitution is not able to take evidence, even though they are somewhat susceptible about the factual aspects and taking very crucial decisions, ignoring evidence in the strict sense. May I proceed? Any confusion or any doubt regarding that point?
No, sir, no.
Okay. Now, I think we can go to the interpretation class. Fact. I think this is one of the most classical definition, because as rightly states, fact means and includes anything, state of thing, relation of thing, capable of being perceived by your sense. Anything, state of thing, relation of thing, capable of being perceived by your sense. Then it again says, any mental condition of which a person is conscious. This is one of the most classical definition on facts. I am very much interested with that definition, and even when I am conducting classes in my college, I am interpreting it in different ways. See, anything is a fact. State of thing is a fact. Relation of thing is a fact, provided it is perceived by your sense. And what you mean by two crucial words? One is perceived and the second one is sense. Perception is a matter of difference. My perception and your perception may be different in different ways. But the court presumed a reasonable standard of perception for all reasonable and prudent persons. And how you perceive by your sense. And what you mean by sense? Sense simply means we sense things with our 5 organs: eye, nose, tongue, ear, and skin.
The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional